for being here with us today. You issued a very important statement earlier today, which I urge all Americans to read. And I'd like to ask you, Judge, about one of the sentences in your statement and ask if you could explain to us the significance of it. You say, had the Vice President of the United States obeyed the President of the United States, America would immediately have been plunged into what would have been tantamount to a revolution within a paralyzing constitutional crisis. Could you elaborate on that for us, Judge?
Thank you, Madam Vice Chairman. That passage in my statement this morning referenced the most foundational concept in America, which is the rule of law. Thus, as I interpret your question, you were asking about that foundational truth of these United States, which we call America. The foundational truth is the rule of law. That foundational truth is, for the United States of America, the profound truth. But it's not merely the profound truth for the United States. It's also the simple truth, the simple foundational truth of the American Republic. Thus, in my view, the hearings being conducted by this select committee are examining that profound truth, namely the rule of law in the United States of America. The specific question, of course, before you and before the nation, not before me, is whether that foundational rule of law was supremely violated on January 6, 2021. Now, to the question specifically that you asked, Madam Vice Chair, I believe that had Vice President Pence obeyed the orders from his president and the President of the United States of America during the joint session of the Congress of the United States on January 6, 2021, and declared Donald Trump the next President of the United States, notwithstanding that then President Trump had lost the Electoral College vote as well as the popular vote in the 2020 presidential election. That declaration of Donald Trump as the next president would have plunged America into what I believe would have been tantamount to a revolution within a constitutional crisis in America, which in my view, and I'm only one man, would have been the first constitutional crisis since the founding of the Republic.
Thank you very much, Judge, for your solemn attention to these issues and for your appearance here today. We're going to describe and discuss in detail what happened. And as we do, I'm going to describe a few of the details now of some of the actions taken by a gentleman named Kenneth Chesebro. After the Electoral College met and cast their votes on December 14th, actually the day before they met, Kenneth Chesebro sent a memo to Rudy Giuliani, the president's lead outside counsel. Mr. Chesebro wrote to Mayor Giuliani that the vice president is charged with, quote, making judgments about what to do if there are conflicting votes, close quote. Mr. Chesebro wrote that when the joint session of Congress got to Arizona in the alphabetical list of states, the vice president should not count the Biden votes, quote, because there are two slates of votes. His justification, which we will learn more about in our next hearing, was that a group of Trump supporters in Arizona and other swing states decided to proclaim themselves the true electors for the state, creating two sets of electors, the official electors selected by the state and a group of fake electors. This document was ordered to be produced to the Select Committee by a federal district court judge. As you will see on the screen shortly, Judge David Carter wrote, quote, the draft memo pushed a strategy that knowingly violated the Electoral Count Act. The judge concluded that, quote, the memo is both intimately related to and clearly advanced the plan to obstruct the joint session of Congress on January 6, 2021. A few days later, Professor John Eastman took up this cause. Eastman was at the time a law professor at Chapman University Law School. He prepared a memo outlining the nonsensical theory that the vice president could decide the outcome of the election at the joint session of Congress on January 6th. You will see portions of this memo on the screen. In the first line, he wrote, quote, 7 states have transmitted dual slates of electors to the President of the Senate. But Dr. Eastman goes on to rely on those so-called dual slates of electors to say that Vice President Pence could simply declare President Trump the winner of the 2020 election. Mr. Jacob, were there in fact dual slates of electors from 7 states?
No, there were not.
And just a few days after that, Dr. Eastman wrote another memo. This one, quote, wargaming out several scenarios. He knew the outcome he wanted, and he saw a way to go forward if he simply pretended that fake electors were real. You will see that memo up on the screen now. Here, Dr. Eastman says the vice president can reject the Biden electors from the states that he calls, quote, disputed. Under several of the scenarios, the vice president could ultimately just declare Donald Trump the winner, regardless of the vote totals that had already been certified by the states. However, this was false, and Dr. Eastman knew it was false. In other words, it was a lie. In fact, on December 19th, 2020, just 4 days before Dr. Eastman sent this memo, Dr. Eastman himself admitted in an email that the fake electors had no legal weight, referring to the fake electors as, quote, dead on arrival in Congress, end quote, because they did not have a certification from their states. Judge Luttig, did the Trump electors in those 7 states who were not certified by any state authority have any legal significance?
Congresswoman, there was no support whatsoever in either the Constitution of the United States nor the laws of the United States for the Vice President, frankly, ever to count alternative electoral slates from the states that had not been officially certified by the designated state official in the Electoral Count Act of 1887. I did notice in the passage from Mr. Eastman's memorandum, and I took a note on it, and correct me if I'm wrong, but he said in that passage that there was both legal authority as well as historical precedent. I do know what Mr. Eastman was referring to when he said that there was historical precedent for doing so. He was incorrect. There was no historical precedent from the beginning of the founding in 1789 that even as mere historical precedent, as distinguished from legal precedent, would support the possibility of the Vice President of the United States quote, counting alternative electoral slates that had not been officially certified to the Congress pursuant to the Electoral Count Act of 1887. I would be glad to explain that historical precedent if the committee wanted, but it would be a digression.
Thank you very much, Judge. I know my colleagues will be pursuing that issue in more depth, and now I'd like to yield back, Mr. Chairman.
Thank you very much.